Your Honor, we're here this morning in case caption State of Ohio versus Lorenzo Robinson, case number 25 CR 000180. We were last here on September 5th, at which time, following a jury trial, the defendant was found guilty of count 1, having weapons under disability, felony of the 3rd degree in violation of Revised Code Section 2923.13A3, as well as count 3, possession of cocaine, a felony of the 5th degree in violation of Revised Code Section 2925.11. The case was then referred for a pre-sentence report and investigation and a drug and alcohol evaluation. Those have been somewhat completed, and we are here today for purposes of sentencing. Defendant is present with his counsel, Mr. Corey Hinton.
Thank you. Mr. Hinton, any reason not to go forward with sentencing?
No such reason, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. As you know, Mr. Robinson did contest the charges in this case, but nonetheless, in light of the verdicts reached by the jury, as far as sentencing is concerned, I'd ask the court to put emphasis on the fact that the conviction for possession of cocaine F5 was a residue amount of cocaine, so obviously a very small amount of cocaine as far as that charge goes. As far as the other charge goes, the weapons under disability, the court was able to hear from multiple witnesses regarding this during the trial. I'd ask the court to take what was said into consideration for mitigation, specifically the side of the story that was presented by the defense as far as how the guns were positioned in the vehicle.
Let's consider that side and not the other side.
Well, for purposes of sentencing, I am asking you to consider that although there was a conviction, it may have been a situation where the facts may not have been as serious as other cases with having a weapon under disability, where there's more of a straightforward, clear-cut demonstration of possession or access. I would also ask you to take into consideration the fact that there has been a several-year span since the last time Mr. Robinson had issues with a felony level criminal case. Mr. Robinson has been in the jail for almost 6 months. We would be asking that you place him on community control sanctions, give him credit for the jail time that he's already completed so that he can be released, and subject to other conditions of community control that the court would impose. I understand that the pre-sentence report was incomplete. I discussed that with Mr. Robinson. He did indicate that specifically in the drug and alcohol evaluation, a trigger was hit with him where questioning about his family arose, and he felt uncomfortable to some extent speaking about that, especially in the context of a drug and alcohol evaluation, so that made him not as forthcoming as he would have liked to have been. But certainly, Your Honor, I think that because the pre-sentence reports were at least completed to some extent, community control would be a viable option. If the court does not feel that community control would be appropriate and that a prison sentence was going to be ordered, we would ask for something at the lower end of the spectrum, again, for the reasons that I previously stated. Thank you, Your Honor.
Thank you. Mr. Robinson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
I do.
Go ahead.
I just don't understand how, I just actually proved to y'all I didn't do nothing wrong at all, and I'm still convicted. I just don't understand that at all. Which I don't understand. I take accountability for everything I did wrong. If I did anything wrong, I wouldn't even took it this far. I wouldn't. I would have been sentenced already.
Is that the last thing you said?
I would have been sentenced already. Got it over with if I did anything wrong. I actually didn't do nothing wrong this time. And I'm cool with that. Like, I got a smile on my face. I just got my mental together. I want to say thank y'all for that because, like, everybody need a mental check sometimes. And I had a reality check in that jail. That ain't for me, bruh. That's not for me at all. I grew up. Y'all didn't want me to grow up, but it's cool. People grow up. People do grow up. Sorry. But other than that, y'all taking me from my family, and I didn't even do nothing wrong. Why? That's all I'm asking. Why? I ain't got nothing to say.
Thank you, Mr. Hinton. Anything else you want to say on behalf of your client?
Nothing further, Your Honor.
Ms. Linden for the state.
Thank you, Your Honor. Your Honor, as I indicated in chambers, the state is requesting a prison term. I'm not looking at the lower end because he has been to prison several times before. The last time, I believe, was 13 months. The defendant has a history back to 2007. His history is riddled with drug charges and disrespect for the law, disrespect for probation, refusal to complete things. He refused to complete this PSR and the other paperwork. This is not his first rodeo. It's not as if he doesn't know what the process is. And in terms of looking at even some of his history before, when he was asked to do some things for NeoCap, he refused to be interviewed for NeoCap back in 2021. He's had a bunch of issues with that. Here with the institutional summary even, it's riddled with him disobeying, the officers disrespecting people, punching an inmate in the face. He had that positive marijuana screen, and then I've never read a report where someone who's doing a drug and alcohol evaluation had such an issue with somebody that they had to have a corrections officer stand by because of it. And he was resistant to answer any questions. He says something to the effect of, I lied on the PSI because I never even did drugs before, which is clearly not true. He got very belligerent when there were questions asked about the family, and I know Lisa Friend tried very hard to be cool, calm, and collected with him, but he continued to be uncooperative and basically told her to stop asking dumb questions. So in terms of that and looking at the level of disrespect that he's had in his history, there's no way that he's amenable to community control. He takes no responsibility for his actions at all. And when we look at his history, there's just not a way to find him amenable to community control sanctions. If he can't even comply with simple things like completing a PSR or answering some questions, certainly community control is not appropriate. This is a report that's filled out to try and assist, at least for the court and for anybody involved, to know a little bit more, and could be a positive for him, but even for that, he didn't want to even engage in any of that. He does have 175 days of credit for time served, and we would ask for the forfeiture that we requested in the beginning as well, but we would ask that a prison term be imposed. Thank you.
Thank you. This court has reviewed there's no pre-sentence report that was completed. I reviewed the information that was provided to the court by the probation department, but a complete pre-sentence report investigation was not completed because of the defendant's refusal to cooperate and provide the information that was requested of him. I don't have a completed drug and alcohol evaluation because of the defendant's refusal to cooperate and talk with the evaluator in that case. She made an effort, she brought him up, she talked to him, and he just sat there saying, I ain't answering that, it's none of your business, she needs to stop asking me these dumb questions. And as the prosecutor alluded to, I haven't seen a report like this where they need to bring a corrections officer in to sit in with her because of the defendant's attitude that he was presenting at the time of the interview. So I don't have a drug and alcohol evaluation. I've considered the facts and circumstances of the offenses. I presided over the case, heard all the facts, taken those into consideration. Take into consideration what's been said here in court today by the defendant, his lawyer, the prosecutor. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911. As for the factors in 2912, nothing stands out factually indicating it's more or less serious. This court is not required to adopt the defense's version of what happened in this case in terms of why he may have been in possession. No, he completely denies it. He says he didn't do anything wrong. But I'm not required to take their version of this and then make us finding that, thinking of their version, this is less serious than normal. I heard all the evidence. In my view, the jury came up with the correct verdict. All this has been considered, however, in light of the purposes and principles of sentencing again. Nothing makes it more serious, nothing makes it less serious. As for recidivism factors, many of these factors are present. The defendant has a lengthy history of criminal convictions as well as juvenile delinquency adjudications when he was a minor, going back, what are we at, almost 20 years, 2007, so 18 years of criminal conduct, delinquent conduct. He's been to prison on multiple occasions, I think 4 times.
No, 3.
Only 3. He's got multiple probation violations, so he hasn't complied or he's failed to comply with the previously ordered sanctions of a court. Multiple probation violations, so he's been
I
given
never got a chance to be on probation, so I was last
So
time.
you've had a chance to speak. Now it's my turn. I'm looking at your record. You've been on probation before. You're telling me you haven't been on probation before.
I have not.
Well, you're lying.
I have not been to the joint 3 times.
You were on probation to Judge Collins in 2010, and there was
No,
2
I
separate
wasn't.
probation.
You sent me to prison.
On probation violations,
No.
well, you were given 1 year of probation, 90 days jail suspended, and then you were given a probation violation, and you were continued on probation. Then another probation violation, you were sent to prison. You were given probation by Judge Lucci in 2020 for the attempted failure to comply with an order of a police officer. You were violated and went to prison.
No, I went to NeoCap.
And then you
I didn't
violated
violate.
and you went to prison.
He told me because they was crushing
NeoCap is probation. If you go to if you get NeoCap, you're on probation.
That's not my fault. They was messing up my pills when I
I
was
don't know why I'm
there.
arguing with you. You were given 3 years of probation with conditions. One of the conditions was NeoCap, and you've violated your probation, and you're ultimately sent to prison. Am I reading that wrong, Kaylee?
No, you're correct.
You can look at the record. You can look at the docket.
I know what I did.
Yeah. Apparently you don't.
I do. I'm the one who
You
went to
got
prison.
a very poor institutional record when you were in jail with disciplinary incidents and infractions that you committed. There is absolutely no remorse, let alone genuine remorse, but no remorse at all, except no responsibility. Violated conditions of his bond and testing positive.
I didn't violate that either. I had no stipulations.
It's clear that the defendant is not amenable to community control sanctions. He can't even sit here quietly as the court is speaking. He keeps interrupting. He's been given a chance to speak, but he keeps interrupting. He won't cooperate with probation. There's not a complete PSR. I'm not even authorized to put the defendant on probation because he wouldn't cooperate with them. He wouldn't cooperate with the drug and alcohol evaluation. He has zero respect for anyone with authority. He's going to do what he wants to do regardless of what anyone says. You even said in municipal court, you're just going to keep driving. You don't care what people tell you. You're going to continue driving cars regardless of what the status of your license is. You're going to do whatever you want to do. And someone with that attitude will never be successful on probation. Prison is consistent with the purposes and principles of sentencing. Therefore, it will be the sentence of this court that on count 1, defendant serve a term in prison of 30 months. On count 3, serve a term in prison of 6 months. I'll run those concurrent for an overall prison term of 30 months in prison. He has credit for 175 days he's already served. I need to advise you upon your release from prison, You may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can send you back to prison. That's punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. I'm going to order the forfeiture any interest the defendant has and the items set forth in the forfeiture specification in count 1 and count 3. Defendant's ordered to pay all costs incurred in this action. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Lastly, I need to advise you that you do have the right to appeal the conviction that was found in this case. Specifically, if you are unable to pay the cost of an appeal, you have the right to appeal without payment. If you're unable to obtain an attorney for an appeal, you have the right to have a counsel appointed for you to do that without cost to you. You further have the right, if you are unable to pay for the cost for the documents necessary for an appeal, including a complete transcript of the trial and all the hearings that we had, the suppression hearing and the other hearings here had here in court. You have the right to have those documents and transcripts provided for you without cost, and you have the right to have a notice of appeal timely filed on your behalf. Now, Mr. Hinton, do you know that the defendant's intention in regards to that issue? Are you going to be representing him on appeal? Does he want someone else appointed for him on appeal? Did that decision been made yet?
Your Honor, it's a decision that would still have to be made.
Well, the only thing I ask then is that you make sure that his right to have notice of appeal timely filed is protected. So even if it's not going to be you initially, make sure at least that gets filed, and then we can go from there.
Okay, thank you.
Ms. Linden, is there anything else for the record at this time?
No, Your Honor, thank you.
Mr. Hinton?
Nothing further, Your Honor.
All rise.
get credit for about 6.
In court, she's accompanied by her attorneys, Mr. Richard Perez and Mr. Hector Martinez. She was last before the court where she entered a plea of guilty to 1 count of trafficking in drugs, felony of the 5th degree, another count of trafficking in cocaine, felony of the 5th degree, possession of cocaine, a felony of the 3rd degree, and receiving proceeds subject to forfeiture, a felony of the 5th degree. At that time that the plea was entered, the court ordered a pre-sentence investigation along with a drug and alcohol evaluation, a psychological evaluation. Those having been accomplished, we are here today for sentencing.
Thank you. Any reason not to go forward with sentencing? Mr. Martinez?
Good morning, Your Honor. Hector Martinez here on behalf of Ms. Herzenstein. We have reviewed the pre-sentence report. It seems to be accurate. There's no additions, deletions, or corrections from our end, and we're ready to proceed with sentencing.
Very well. Is there anything you would like to say at this time on behalf of your client, or anything you'd like to present for the court's consideration?
Yes, Your Honor. I would like to speak on Ms. Herzenstein's behalf. Initially, we have a few people who would like to address the court on her behalf prior to my presentation, so I'd ask them to introduce themselves one by one and speak to the court.
You have a microphone?
Yeah, thank you.
Whoever it is that would like to speak at this time, I'm going to have you, we'll hand you a microphone to speak into. Just state your name, spell your last name for the court reporter, and then take your time and say whatever you'd like me to know. I probably could just, I don't know if you need to hold it or set it there, whatever works.
Test.
You just hold it down lower and it'll pick it up.
Okay. Amy Herzenstein, I'm Zoe's mother.
Okay.
Heraclitus, a Greek philosopher, once said, "No man ever steps into the same river twice, for it is not the same river, and he's not the same man." We are forever changing, and the river is also forever changing. Before the accident, Zoe had called me one day to share with me her thoughts about her goals in life. Sorry, let me just take a breath.
Take your time.
Since Zoe had moved out of our home, she had worked a number of jobs at the same time to support herself. She did not ask for assistance. She was independent and capable. At this particular juncture, she had given great thought to her current way of life and the changes that she wanted to make for a productive and meaningful future for herself.
Sorry.
She shared that she was tired of the late hours of bartending and other aspects of the job that she felt she had outgrown. She had accepted a job at a Willoughby Canning company that had regular business hours and also had tuition assistance for attending college, among other benefits. As she laid out her reasoning and her proactive actions, I felt so proud of her introspection and, more importantly, her actions. She was telling me all of this after the fact. She had the confidence and the strength to act on her beliefs. Also, before the accident, Zoe had invited us to hear her sing with her band. What a phenomenal night that was. It was a large band with all of the pieces. The most impressive piece, in my opinion, was Zoe's incredible voice. It was a magical night indeed, watching my talented daughter shine her light. Zoe played many instruments herself. She was first chair in high school for flute. Not only did Zoe play instruments, but she wrote her own songs. She was truly gifted. But what made her gifts special was her inner light that shined through her music. And yes, you could say I'm biased, but everyone who heard her would comment on this. Zoe was following her passions while practically working to support herself. She was growing and evolving. I was so very proud of her. On March 14, 2020, Zoe's car was hit head-on by a drunk driver driving the wrong way on the freeway. The two cars of Zoe's friends that she was following were able to see the car coming at them and swerved out of the way. Zoe had no way of seeing the car that struck her at full speed. This horrific accident took the life of her best friend and her best friend's boyfriend, who was also Zoe's good friend, and it injured another friend who survived the accident. The surgeons and the police spoke with us and tried to prepare us. No one thought that Zoe would survive, but Zoe's spirit showed us all. She came out of her coma to discover she had lost her friends and that she had lost her limb and her body as she had known it before the accident. She set herself intermittent goals, and we celebrated each one: to drink water or thin liquid, to get out of bed using the Hoyer lift while she had a fixator bar protruding from her pelvis, to take her first steps with her prosthetic, and many more. There are different ways to approach and deal with our lives. We have various choices to make. We can give up, we can live in victimhood, or we can choose to grow and evolve using our challenges and traumas as teachers and implements of change. Sounds easier than it is. Zoe continually chooses to grow and move past of what was to living in the what is, living in the now. Her doctors told us she would live the rest of her life in pain. She is in a lot of pain daily. To her, most likely, it is from minute to minute, hourly. Pain is horrible to live with. Zoe had spinal surgery, rib fractures, pelvis surgery with a fixator bar attached to her for many months, femur and fibular bones in both legs, a liver laceration, bruised spleen, and a traumatic brain injury. She was on a ventilator and had a feeding tube. The surgeons tried to save her leg by using a vein from her arms and her legs to improve circulation. Unfortunately, the amputation proved necessary. Her recovery was a long one and is still ongoing. However, Zoe's approach to healing is so impressive. I don't know anyone who would be handling it like she is. I've said this all along. She doesn't complain. She does what needs to be done. Instead of performing, Zoe reinvented herself as a concert photographer. She takes the most fabulous photos and captures incredible moments. Her name, Zoe, means life, and that is what she's doing, living. She finds ways to make her life work. All of this is leading up to this very moment. It goes without saying that I'm beyond disappointed that Zoe went the route she did. The fact that we are here today because of this is very hard to accept. Living with insurmountable, endless pain is a very hard way to live and navigate life. Her doctors talked to us extensively about this. The impact her body endured from the accident was monumental. Zoe has accepted responsibility and is making strong efforts to straighten out her life. She has been in therapy, attending IOP, studying psychology, all the while working with how to live with pain and continual adjustments with her prosthetic. When Zoe was in school, she volunteered at the Friendship Circle, working with children on the autism spectrum. She would sit next to a boy on the bus who was being teased and didn't have friends. Her interest in majoring in psychology is very fitting. She is on a trajectory to be a contributing member of society. What a phenomenal healer she will be with the background of all that she is overcoming. Growth certainly is not linear. These were not the zigs and zags that a parent potentially foresees. But it's where we are now, a pivotal moment in time. Zoe is showing evidence of introspection, acceptance of responsibility, and productive actions and behavior. She is showing the willingness to make the changes necessary and to make things right. I'm so very proud of her ability to deal with everything she has experienced from the accident on to this day. She isn't playing the blame game. She is showing up, taking responsibility, healing, and working productively. This situation has shaken Zoe to her core. She is on a course of healing, correction, and growth. It is again evidence that no man ever steps into the same river twice, for it's not the same river, and he's not the same man. Thank you.
Thank you.
Let's let David go first.
David Drew, I'm Zoe's partner. I'll be reading from my phone. I've only known Zoe for about 3 years. It's hard for me to tell you what the effects of her accident were firsthand. I will say that I've seen it affect everything from jobs like being a barista in a fast-paced environment, her photography, her singing, even just going for a walk in the woods, everything. I can tell you, however, about the person she is today. When I met Zoe, the first thing that struck me about her was this. Here was a person who had every reason to give up, to let the sadness win, and she does not. She finds life's small miracles and celebrates them. It was such a beautiful thing to witness, and a trait that I've tried to adopt more myself. The longer I got to know her and the closer we became, I realized it's even bigger than that. She takes every opportunity to help those around her. She lifts people up. I've literally seen her take food from her own refrigerator and give it to her friends because she didn't have money to buy them groceries, but she wanted to make sure they were cared for and got to eat. On days that we're together that I have to go to work, she gets out of bed at 4:30 in the morning with me to cook me breakfast and make sure I have a lunch and maybe a cup of coffee for the ride in, things that I don't even do for myself. Since the incidents that led to this court case, I've watched her strive to change her life with the same drive and tenacity. She has accepted responsibility for her wrongs. She attends meetings nearly every day. She shifted her focus to things like physical therapy so she can learn to walk again. She's become a talented gardener, adorning both our homes with beautiful houseplants and herbs that we use to cook every day. She also started attending college courses for a degree in psychology. All of these things are so that she can become the best version of herself, and she works tirelessly at them. She wants to not only better herself, but also to be someone everyone around her can count on. Thank you.
Thank you, sir. Mr. Martinez?
My name is Jonathan Herzenstein. I am Zoe's father. And today is a little more emotional for me than I thought it would be. And everything that Amy has said and Dave has said is very hard for me to elaborate on. I did write a letter to the court reflecting on Zoe's life, what it's been like, what she was like as a child. She was always, she could sing before she could talk, and she's always been so full of life. And the events that occurred when she was hit by the drunk driver, while it changed all of our lives, it did not deviate Zoe from her path of living. And she never uses the accident as an excuse for anything that she could use it for. She's very, very impressive as a human being. Each of us errs in life. I believe there's redemption for everyone. Zoe's done everything in the world that she can to better herself and better her life. From enrolling in college, from going to IOP religiously, to changing the people that she chooses to keep company with. Her life has been a miracle to me. Her survival has been a miracle. And I hope that, I know that she's learned from this, and I hope that moving forward that she'll be treated fairly.
Thank you, sir. Anyone else, Mr. Martinez?
All right. I'm going to have Zoe address the court, then I'll wrap things up.
Ms. Herzenstein, you have the right to address the court before your sentence. You can say anything you like. Is there anything you care for me to consider at this time? Or anything you want to say?
Oh, yes, sorry. Your Honor, they're basically what my parents and my partner just said. I have no excuse to give you. I could give you any of the things they said, but I knew what I was doing was wrong, and I did it anyway. So I am deeply sorry for my actions. I am very thankful that it happened, though, because without that happening, I don't know if I would have had as much of a drive to change my life and go back to school, take my physical therapy as seriously, and to work on myself as a person. So although most people probably wouldn't need what happened to happen to do that, for me, it's a really great way for me to never want to do those things again. And I'm grateful that I'm able to still be here today and to say this in front of you.
Thank you. Mr. Martinez.
Thank you, Your Honor. I'm going to expand on what Zoe just said, that she's thankful that these events happened. And I can sit here and criticize how this all, how this winds up to us being in this particular spot, that her friends who she was partying with go to the Lake Harney Narcotics. They end up purchasing drugs from her and turn that into the Lake Harney Narcotics. Then she is ensnared in this. But as Zoe said, she was backsliding, I think. Well, we know that because the accident happened in March of 2020. She really attacked her rehabilitation with great fervor and zest thereafter. And then probably the pain got to the point where she said, I can start using these drugs to mask that pain. And she has indescribable pain, physically and mentally. None of us in this court can imagine waking up from a coma and feeling what she felt, losing a limb, losing your best friend, losing your best friend's boyfriend. And then thereafter, just being in this incredible pain every day. And what was she using? She was using cocaine. She was using ketamine. Ketamine masks that pain. It's used as an anesthetic for animals. I think Zoe felt that was masking her pain. It was masking her emotional distress from the accident. And as she is telling you today, she is thankful that this happened because it has led her to a place where she can reset her recovery. She went into Signature Health. She enrolled into the treatment program. She completed the treatment program. She's been going to meetings. As David had indicated, I've talked to her about attending even more meetings, and she's in accordance and in agreement with that. She's working on her mental health. As we discussed earlier, she needs to get a psychologist who really she can connect with and work on her issues. I think what's also been kind of glossed over here is that she did suffer a traumatic brain injury in this accident. And I think that affects her decision-making, impulse control. She has an appointment, obviously, with her neurologist in December, which I think is very important that she keep. Zoe and I have talked about her rehabilitation, that she needs to get in there and do her physical therapy because she has a singular goal, which is to get the prosthetic leg and to walk again. And she needs to continue to work every day towards that goal. She needs to get in that physical therapy. I know her parents are encouraging her. We're encouraging her. She needs to have that zest that she has for life and for helping her friends and for dealing with her drug addiction. And also, she needs to push forward with that physical rehabilitation. And Rick and I are both confident that she's going to do that, and we're going to follow her progress. Now, I can belabor going through these sentencing factors here, Your Honor. Number one, she has tremendous support from her family. She has tremendous support from her friends. The public does not need protection from Zoe. It does not. Zoe needs help. We appreciate Ms. Henley's pre-sentence report. We appreciate Ms. Friend's comprehensive assessment, which we agree with 100%, that she should complete her aftercare, that she should immerse herself in mental health counseling, that she should do all those things that Ms. Friend asked her to do, that she should go to 12-step meetings at least 3 to 5 times per week. One doctor, one dentist, we get all that. She's prescribed some medications. She will be 100% compliant with her medications. I also want to emphasize the fact that Zoe did lose her ability to sing at the level that she sang prior to this accident, but I love what her mom said, that Zoe has reinvented herself. She loves music. Okay, what can I do to continue that passion for music? Well, she's a photographer. She goes to the concert. She takes tremendous photographs of the shows. That's a passion of hers. She should continue that. We want her to continue that. She's willing to do whatever community service this court would order. I think Zoe is capable of performing community work service for this court. And I know she thinks she's capable of doing that. With regard to the presumption in this case of any prison time, it's our position that that has been rebutted. Zoe has no prior juvenile history. She has no prior criminal history. These are circumstances that are not likely to recur. She shows genuine remorse for what happened. She has a drug and alcohol or drug addiction. She acknowledges that drug addiction. She's taken steps to treat that drug addiction. She hits all the sentencing factors, Your Honor, to overcome that presumption. So it's our position that Zoe is an excellent candidate for community control sanctions, that this court would punish her by, well, she's being punished. She's getting a felony conviction. She already served 3 days in jail. She has embarrassed her family. She's embarrassed her attorney, her other attorney. She feels that, but she needs to move forward in this. The punishment has been imposed. The public does not need protection from Zoe in this case. She's not going to do this again. She's not a danger to this community. And we need to promote her effective rehabilitation. She can do that. She's already doing that. I am confident that this court's adult probation department will give her whatever other support she needs to do that. And we would ask the court to take all that into consideration in fashioning an appropriate sentence of community control sanctions. Thank you.
Thank you. Anything else on behalf of the defense?
No, Your Honor.
Okay.
Thank you.
Ms. Mulligan for the state.
Your Honor, the state will recommend that she be given a chance at community control.
This court has reviewed the pre-sentence report and investigation, psychological evaluation, and reviewed the sentencing memorandum that was found in this case, all the attachments there too, and the letters. I have considered the facts and circumstances of the offenses involved, the nature of the offenses involved, and I have considered everything that's been said here today by her parents, her partner, counsel, defendant herself, as well as the prosecutor's recommendation. I consider all of this in light of the purposes and principles of felony sentencing, which are set forth in 29-2911 of the revised code. So the factors in 29-29 12, I don't find any factors present making the offense more or less serious. For recidivism factors, no factors are present indicating recidivism is more likely. As for the factors indicating it's less likely, the court notes the defendant doesn't have any prior delinquency adjudications, no convictions as an adult, led a law-abiding life for a significant number of years, appears to show genuine remorse. There is a presumption for prison in this case. Despite that, the court will give the defendant a chance on community control sanctions, finding that prison is not consistent with the purposes and principles of sentencing. The defendant is amenable to an available community control sanction. So I'm going to place the defendant on community control sanctions for a period of 2 years. As part of her sanctions, there are going to be some consequences, though. This is pretty serious what happened here. I mean, you were multiple sales with large amounts. The typical deals that we deal with here in Lake County are much smaller amounts. You said you were selling just enough to be able to support your habit. Well, you were selling $600 and $450 and $450. That's well more than we see here in Lake County normally. And a person with those transactions and those and that conduct and the amount of times if they don't go to prison, which happens frequently, they're doing significant jail time. I'm going to order as conditions of your community control sanctions that you serve 30 days in the Lake County Jail, which is well less than what most people would serve in these circumstances. You have 3 days of credit. Upon your release from the jail, I'm going to order that you serve 60 days of house arrest with GPS monitoring through the jail diversion program, which then the probation pays for that. It's not self-pay. I will allow you to be released to attend medical appointments, probation requirements and obligations, Are you working right now?
I have a job doing handicap services.
I can't hear you.
I have a job that helps with handicap patients or festival attenders at concerts and events, but it's only temporary. It's like a contract job.
Well, I'll let you attend. If there's a job that you have, I'll let you do that. I mean, if a festival comes up and you're going to do that, I'll allow you to do that, but you need the probation know about that. It's not going to be a regular thing, it doesn't sound like. So if something like that happens, I'll allow you to attend that, but probation needs to be advised prior to that.
Thank you.
So release for medical appointments, which includes, mental health as well, obviously. And to do whatever to accomplish whatever obligations are required as a result of probation. Further conditions, you're not to use any drugs or alcohol, and that includes no marijuana. You're to submit random urine screens. They must be negative. Positive screens, a violation. You can't tamper with the urine screens, substitute someone else's, do anything like that. You're to attend 3 AA meetings a week and have a sponsor. I'm going to order that you perform 40 hours of community service. I'm sorry, I meant it was 30 hours. 30 hours of community service. I'm not going to order any specific requirement about employment. If you want to get employment, that's fine. I am going to say that you're not to be employed at any bars or taverns. So if you are going to work, it's not going to be there. You're to take all your medications as prescribed. I want you to complete the aftercare program that you're currently in with Signature Health. You should continue with your mental health medication management through Signature Health.
Your Honor, she completed that aftercare program already, is my understanding.
Okay, well, if it's completed, then, all right. If it's completed, then
Yeah.
fine. If not, I'm going to put that in there. If it's completed, then she's
Sure.
satisfied that.
Thank you, Your Honor.
What is the growth therapy that you were doing? Are you still doing that?
No, I'm looking for a new counselor. I wasn't receiving the level of care that I would like.
What is that?
I would like a psychologist, somebody that's well
No.
versed.
What is the growth therapy?
Oh, it's an online therapy. It's a video chat therapy.
Well, you need to be obtaining psychological counseling.
Yes.
You need to do that immediately. I don't want gaps. I don't want you to be doing it and then not be happy, so you stop and look for someone
So
else. You can look for someone else if you want, but you're going to continue to stay in it until you find the other person, so you can transition right into that. I don't want it stopping and then there being nothing going on.
I have an appointment on the 21st, I believe. You need a referral from a doctor to get a psychologist referral through Metro Health. So I have an appointment to get a referral for that.
Right, well, you need to start that up immediately. That's mental health counseling, psychological counseling, right?
So the 21st you would be in jail.
I want you to comply with all recommendations given at your upcoming neurological appointment. And you should utilize case management services through Signature Health to assist you with community resources as needed. Prepare court costs and supervision fees. There's a mandatory fine required to be imposed on a lesser included offense of count 8. I'll impose the minimum mandatory fine of $5,000.
Judge, we're going to file an affidavit of indigency. Would we be permitted till the end of the day to do that? We neglected to do that.
How is that? We've got
Pardon?
two private attorneys here.
Well, it didn't come from her. She did not. She has family that retained us. She makes, I think, about $1,300 a month. through Social
Because,
Security.
I mean, if something's filed before the sentencing entry is filed, and that's not going to get signed today, I can tell you
Okay.
that, then
We'll get it
I'll
filed
consider
today,
that.
Judge.
Okay. I'm going to order the four.
Pardon?
I'm waiting. If you need to talk to your attorney, go ahead.
I'm able to request time to just be able to get my affairs and home in order so that I'm able to make sure that my cat has someone to take care of him, someone has a key to my house and stuff like that.
We can ask him, but it's unlikely he's going to do that. You're going to probably have to rely on your family to do that. Okay.
What's that? Okay.
Judge,
I mean, you don't have to tell me what she said. I mean, it's up to
yeah, she was going to ask if the court would consider giving her a few days to report.
Well, we're not to that. Let me finish my sentence.
All right, thank you, Your Honor.
I'm going to order the forfeiture of $1,045 regarding count 11. Is that the correct amount?
Yes, Your Honor.
I'll dismiss the balance of the indictment. Stanley, is there anything else I should be considering?
No, Your Honor, thank you.
Ms. Herzenstein, you understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise you if you fail to comply with any of the conditions of your community control sanctions, any of the rules of probation, which will be gone over with you, if you leave the state of Ohio without permission from this court, or if you commit any new offenses while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years, I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 12 months on count 3, 12 months on count 6, 36 months on the lesser included offense of count 8, and 12 months on count 11. Those would all be served consecutive to each other for an overall prison term of 72 months or 6 years in prison. You understand that?
Yes, Your Honor.
All right, Mr. Perez, you want to be heard on something, Amanda?
Judge, two things. Appreciate you allowing us to file the affidavit of indigency. She would ask if you would give her a few days before she has to report to take care of some things with her home and situations that she will need in the jail. The last time she was in jail for those 3 days, they would not let her take her wheelchair in. They gave her a manual wheelchair that was really not wide enough for her to sit in. It was difficult for her. We would ask if the court would allow, and I know this is up to the jail, if they would, if they would search her equipment, allow her to take that equipment in. Also, she needed diapers and things when she was in there that she wasn't getting the last time. It was made very difficult. So, I can approach some of these things with the sheriff. I don't know if you could do anything to assist in that regard, but
That's up to the sheriff. I don't interfere with their security measures that they get involved with. In regards to reporting, this has been set for some time, and she was a presumption for prison in this case. Whatever matters needed to be taken care of should have been taken care of prior to coming in the court here today. So that request is denied. Is there anything else for the record?
No, Your Honor.
Mr. Martinez, Mr. Perez?
no, Your Honor.
No, Your Honor.
Your Honor, we're present today in the state of Ohio versus Dale Setzer, case 24 CR 1186. We're here today for the purposes of a sentencing hearing. The last time we were before this court, the defendant was found guilty by a jury of all 8 counts in the indictment. Today, the state would elect to proceed to sentencing on count 2, felonious assault with a deadly weapon against John Cadis. We would state that counts 1 and 5 merge into count 2. Count 4, felonious assault with a deadly weapon against Nora Stinson. Counts 3 and 6 would merge into count 4. And count 8, failure to stop after an accident, a felony 5. Count 7 would merge into count 8. Thank you.
Thank you. Mr. Martinez, any reason not to go forward with sentencing?
Good morning, Your Honor. Hector Martinez here on behalf of Mr. Setzer. Initially, we would concur with the state's merger position on this case. We have reviewed the pre-sentence report. I was able to review that with Mr. Setzer in the jail, and we are prepared to proceed with sentencing.
Thank you. You answered my first question, then you agree with the merger analysis. Is there anything then you would like to say on behalf of your client?
Yes. Initially, Mr. Setzer would like to address the court.
Mr. Setzer, you have the right to address the court prior to being sentenced. Is there anything you care to say at this time?
I wrote a letter. First and foremost, I'd like to apologize to everybody involved in this accident, mostly to Miss Stetson and her daughter. I truly apologize for what has happened to her and her daughter. If I could change anything that happened to that day, I would do it in a heartbeat. Hope they both get through this very soon, and I hope they find peace. I'd like also to apologize to John as well. I hope he gets through his injuries and someday gets the help that he might need. I see a lot of himself in me. I see a lot of himself in me from 25 to 30 years ago when I was a using addict. Secondly, I'd like to thank you for revoking my bond and sending me to jail. This is, in the past 43 days, this has been a very big eye-opener for me. Has shown me that just how far I've come and grown in my recovery in my life. Sometimes you don't see just how far you've grown until something bad like this happens. It's shown me in some areas of my life where I've become stagnant and complacent. In my life, in my recovery, I would like to explain that part of where I've been complacent was very hard to explain because I have a hard time finding words. Being in there again. Has shown me that you need a certain mindset and mentality to be in there that I no longer have. There was a CEO, Mr. Dizer, years ago when last time I was there, told me if I didn't like being there, not to do the stupid things that will put me there, and I have not done that. In my recovery, my mindset and mentality today is not to get into trouble and go to jail or do anything that will put me there. Or if it means me losing my driver's license, I don't do it. If it means me paying fines, I don't do it. If it means me running to the cops or getting me in trouble, I don't do it. My mindset today is giving back to the community that I have harmed in the past. In other words, paying it forward whenever I can, and working forever to change that stigma of once an addict, always an addict. And one of our steps in Narcotics Anonymous, which is step 9, is make direct amends to make amends to whenever possible, except when to do so when injured them or others. Some of those people I owe amends to fall under that last part, and the best I can ever do is not to be that asshole I was years ago, and try to be the best person I can every single day, and not go back to that process where I was being a using addict. I owe it to my parents who helped me in my recovery more times than I like to admit. I owe it to Judge Allen who I wrote a letter to thanking him for sending me to jail and the treatment, and who saw something in me 25 years ago that I did not see myself at the time. I owe it to Jonathan and Shannon, who I can only make direct amends to by not being that same person I was that 25 years ago. I owe it to a lot of other people that helped me along the way. I owe it to other people whose toes I stepped on along the way also. But most of all, I owe it to my dog, who's been there for the past 12 years, who's been with me for some very dark days in my recovery. Most of all, I owe it to myself. And thirdly, but last but not least, sentencing. I know I'm looking at a decent amount of jail time or prison time. I will do almost anything to avoid going to prison again. Been there, done that, and I would do anything to avoid it. I promised myself that I would never go back. Not after what I've been through the last time I was there. And remember that mindset mentality that you have, it's even worse in prison. I'm afraid to fall back into that again. I worked too hard, too long to get out and stay away from that mindset. I would do any amount of work release. I still owe my lawyer some money. I would do any godly amount of community service you would like for me to do. I will even work it off helping across the street building a new jail. I know basic plumbing, electrical, I even know welding. If not any of those, I'm pretty sure they can find me a few hours a day. They can find me something for me to do. I'll do any amount of probation or jail time. I will do any amount of probation or house arrest. I could help around the jail. I could fix the tile up front. I could help with a JT program with almost 25 years in recovery and with 14 years clean stretch, I believe. I'd be a big asset to you. I know I'm not. I guess what I'm trying to say overall is that I could be a bigger asset to you and to the court rather than being another empty Lisa's body inside the walls. I will do anything to get me out of here and back to my dog. Her time is coming to an end soon. I would really like to be there when it does, just as she has been there for me. Thank you for letting me speak to this. Sincerely, Dale Setzer.
Thank you, sir. Martinez?
Your Honor, we are asking the court to consider imposing a minimal prison term on community control sanctions if the court disagrees with that, a minimal prison term on Mr. Setzer. Respectfully, it's our position that this was reckless conduct here at the most. Obviously, the jury didn't see it that way. Mr. Setzer did testify. I'm not going to belabor what was said here in open court at the trial. Mr. Setzer, as far as the seriousness and recidivism factors under 29-29-12, we would submit that the assault charges encompass one of the seriousness factors, or within that seriousness factors that victims do suffer serious physical or psychological harm as a result of this offense, so it's not more serious than an average.
Not with count 2 and 4.
Pardon?
One, not with the count he's being sentenced on. I think that one, correct me if I'm wrong, is cause or attempt to cause physical harm with a deadly weapon.
That's correct.
So it doesn't have to be serious physical harm. It can just be physical harm.
Thank you, Your Honor. Respectfully, it's our position that Mr. Kiedis had some role in this. I know, obviously, the evidence was presented here, but he was obviously driving recklessly on that day and caused this. I mean, Mr. Setzer, he talks a little bit about his addictions. He did have some problems about 25 years ago. He was in and out of the courts. He served a brief prison term out of Cuyahoga County about 30 years ago. Then he was in and out of the courts for, by his own admission, some drug issues, primarily with marijuana. And Judge Allen did send him to jail treatment and to the Salvation Army program. And since then, Dale's led a law-abiding life for a significant number of years, and I think that needs to be taken into account. He has elderly parents he wants to assist. They're, I believe, 87 and 84 years old. Mr. and Mrs. Setzer has got an elderly dog that he wants to be with. So, you know, he feels remorse for these people. He didn't want anything to happen. He went in and talked to Detective Sergeant on that day, or the next day, told him what he believed happened that day. And, you know, it's our position that this is not more serious than the average offense, that even though there are some recidivism factors as it relates to his past criminal conduct that occurred a significant number of years ago, he does demonstrate genuine remorse, and we would ask the court to take all that into consideration in fashioning an appropriate sentence in this case. Thank you, Your Honor.
Thank you, sir. On behalf of the state of Ohio, Ms. Tuttle.
Thank you, Your Honor. The state is requesting a prison sentence here in the amount of 9 to 11 years. The defendant has maintained that his conduct here was an accident. However, it was assaultive conduct. He talks about this assault like it's something passive that happened to him, rather than taking any sort of accountability for him causing harm to others. This doesn't have anything to do with him being an addict 25 years ago. This doesn't have anything to do with his drug use. This has everything to do with his state of mind and his behavior towards other people on the road in August of 2024. There's a presumption in favor of a prison sentence on these felonies of the second degree, and factors that would tend to support that are that the victims here did suffer serious physical harm. We had John with broken bones in his foot and ankle. We had Nora suffering a concussion. Nora's injury in particular was exacerbated by her age. She was only 5 years old. We heard testimony that she was supposed to start kindergarten the week that this concussion occurred, that it was very hard for her parents to be able to treat her the appropriate way for that concussion because she needed to rest. She's only 5 years old. She wasn't able to rest. It took longer for her to recover. She had to go to school. There were things that needed to be done. Additionally, there's lasting pain from that. John Cadis still suffers pain in his foot. He described that as an arthritis-like pain, something that hasn't gone away, this kind of constant ache in his foot. All of our victims here suffered serious psychological harm. Nora had to start therapy at only 5 years old. She's still in therapy. The court heard testimony about how she's afraid to ride in her parents' car on the highway, how she gets nervous. She asks her parents if they're going to go on Route 2. She's scared to get on the school bus because she thinks they might go on the highway. Her mom has to attend field trips with her in the event that they might go on the highway to get somewhere because she has that much of a fear from this. We heard that Allison also was impacted by this. Something that was a normal, everyday part of her life, driving down the highway as a 30-year-old woman, now frightens her. When she has to get behind the wheel on the highway, she gets sweaty. She gets nervous, she shakes, and she is fearful for driving with her kids in the car on the highway after this happened. We heard how John has night terrors, that he has trouble sleeping as a result of this assault that happened to him. We have 3 different victims here that suffered serious economic harm. Roseanne Carosi had to pay $10,000 out of pocket for a new car that she needed to purchase. Her car was totaled as a result of the crash. She was in that Ford that was the 3rd car that was hit by the Subaru. John Cadis has over $30,000 in medical costs incurred because he didn't have medical insurance at the time that he was hit. All of his debts are currently in collections. He's responsible for those from the harm that the defendant caused. The Stinsons struggled with their insurance company to be able to replace their Subaru. At one point, they had to sell their second vehicle to buy 2 new cars so that they could live their daily life. All of the vehicles involved in the crash have been housed at the Willoughby Police Department since August of 2024 because they've been held as evidence. So this has been an economic harm and an economic loss to everyone that was involved, everyone whose car was hit as a result of the defendant's conduct. Here, recidivism is more likely. The defendant does have 1 prior felony and served a prison term, although we do acknowledge that that was nearly 30 years ago. The defendant has 13 prior misdemeanors. Those are also older. He has numerous traffic violations. But what's most concerning to the state of Ohio here, and what we think is the most indicative of recidivism, is the defendant shows no genuine remorse. The defendant has repeatedly said that he feels bad for the people involved, but takes no responsibility for assaulting anyone, for hitting anyone, for causing the harm here. He really looks at this from like a passive view that something happened to him. He repeatedly testified to this all being John Cadis' fault. He testified to cursing out the motorcyclist, this being the motorcyclist's fault. In his pre-sentence report, he called John an idiot. In the calls that he's making from the Lake County Jail after being incarcerated, he's making statements about how all of this happened because of an asshole motorcyclist. So the defendant still maintains that this wasn't his fault. He's maintained that all of his senses must have failed that day.
What?
His senses must have failed. There's no way that he didn't see, hear, or feel a thing when he crashed into John and that Subaru rolled down the highway. He put pedal to the metal and hoped that nobody would find him. When he was found, he lied about what happened. It's pretty clear from his statements that his mindset is that he doesn't want to be in trouble or go to jail. His mindset isn't that he doesn't want to cause harm to others around him. He's repeatedly said that he doesn't want to get in trouble. He doesn't want to go to jail. He doesn't want to be locked up. Not that he wants to take care of those around him. Not that he wants to be a good citizen. Not that he wants to look out for the others on the road. Not that he doesn't want to commit crime. The defendant's own intentions have been clear all along, and we heard from his own mouth, this isn't going to end well for you. You're on a motorcycle. I'm in a car. He knew he was wielding a deadly weapon, and he knowingly used it to cause serious physical harm. That's why the state is recommending that the defendant serve a prison term that's substantial. It's necessary to protect the public from his conduct. The defendant told us that there was no anger, no road rage, nothing. He said that to the police. He said that at his trial. He said that to the probation department. And what's really concerning to the state is if that's the defendant not angry, just imagine what he would be like if he truly was angry, the harm that he really would cause if he was in a fit of rage. That's why the state's asking for the defendant to serve an indefinite term of 4 to 6 years on count 2, the felonious assault against John Cadis. We would ask for the mandatory Class 2 driver's license suspension to be imposed and ask for the maximum of a lifetime suspension. We ask for a prison term of 4 years on count 4, the felonious assault against Nora Stinson, and the mandatory Class 2 driver's license suspension, the maximum to be imposed of life, and a term of 12 months on count 8, failure to stop after an accident. There's a Class 5 suspension mandatory with that of 6 months to 3 years. We would ask for the maximum suspension on that of 3 years. Victim John Cadis has provided documentation to the court for his medical bills. He would ask for restitution. Roseanne Carosi is not requesting any restitution be ordered, and the Stinson family has conveyed through the Victim's Advocate's Office that they are not requesting restitution. However, they will be pursuing civil action against the defendant. Thank you.
Thank you. This court has reviewed the pre-sentence report and investigation. I received multiple victim impact statements. I've read and considered all of those. I have the opportunity to preside over the trial. I've considered the facts and circumstances, nature of the offense involved. I've considered everything said here today by Mr. Martinez, the defendant himself, read his statement, the prosecutor's comments, the recommendations from each party. All of this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911 of the revised code. As for the factors in 29-2912, factors indicating the conduct is more or less serious. First off, both victims in counts 2 and 4 did suffer serious physical harm. Again, that's not even required to commit to it. Counts 2 and 4. There's physical harm or attempt to cause that. You don't even need to have any harm. But in this case, they both suffered serious physical harm. Stinson family and the victim in that family, in particular count for count 4, also suffered serious psychological harm. For count 4, the injury was exacerbated due to the young age of the victim. also believes that the evidence in the case established not only that was the conduct knowingly, it was done intentionally. The defendant intentionally hit that motorcycle, which is a mens rea that's even more that is required for the commission of this offense. There's no factors indicating the conduct is less serious. As for recidivism factors, the court will note the defendant does have a history of criminal convictions. He served a prison term before. He's not responded favorably. Well, strike that. He served a prison term before. There is no genuine remorse. There's no remorse, let alone genuine remorse. The defendant completely denies any knowledge that he struck the vehicle, any knowledge that there was an accident, and that just defies the evidence that was presented in this court. Defies common sense. Even if to deny knowing that even an accident was called when cars are rolling down the freeway, it's not true. And you could say you're sorry to the victims, and including Mr. Cadis, but then you make these comments about Mr. Cadis with this inappropriate backhanded shot you're taking at him, telling him that you see a lot of him in you, or a lot of you in him, that he's an addict, and refer to him that way. You don't know him. How do you know him that you can stand up there and make any statements like that, except it's an opportunity for you, again, to take a shot at him. And it shows that there's no remorse, and the remorse that you're at least trying to put forth is not genuine.
Your Honor?
No factors indicate recidivism is less likely. Is there something you want to say?
Yeah, I wasn't trying to take a shot at him. My lawyer, Mr. Hector, gave me his past about his DUIs and OVIs and his drug positions, and that's what I had in the past. That's the only thing that I was saying about that.
There's no reason for you to even say that. Even if it's true, there's no reason for you to say that. Why are you giving a diagnosis on this victim or making comments about him in that regard? There's no reason for you to be saying anything like that.
Okay.
That had nothing to do with this case.
I just saw a lot of him in me, that's all.
All that conduct had to do at the bottom of that ramp, and he was wrong in what he did. I don't disagree with that, but the only relevance it had in this case really is that it put you in a rage.
There was no rage, Your Honor.
You're
Honestly,
lying.
there wasn't. There wasn't.
You're clearly lying.
No.
Based on the evidence that was presented. The comments that you were making, I forget exactly what it was. It was said by the prosecutor that you're going to lose. You're on a motorcycle and I'm in a car or truck, whatever he said. It shows that that's not the case. And the other comment that you made, which I think is very relevant here today, that wasn't brought up, is that you made a comment then that actions have consequences. That you cut me off, you didn't engage in that conduct, you made that choice to do that, and now there's consequences, you're going to pay for that. Well, you know what? Actions have consequences. And you decided to do what you did on that day, and there's consequences for that. And that's what's going to happen here today.
I understand that, Your Honor.
Go ahead. I'll let you say what you want to say, but I've already given you a chance to say what you want to say. But if you want to say anything more, go ahead. This is going to be the last chance, though, because I've given you a chance. I'm speaking now, but go ahead, Mr. Setzer.
My aspect of that consequences, your actions consequences were, I lost my license for 15 years because of my consequences and my actions. It took me 15 years to get that license back. That was asking for rides. That was doing everything I could do in every kind of...
You know what, I gotta stop you. I don't need your interpretation of what you meant to say. What you said was actions have consequences, and that was prior to what you went ahead and did. And you said, this is not going to end well for you. You're in a motorcycle, I'm in a truck, or I'm in a car. And those were all comments that were made after he cut you off. as you're going up the ramp. Clearly affected you the way I said it affected you.
Not really.
Enough.
Sorry.
Because you're digging yourself a bigger hole here. Because you're clearly not being genuine. Because the evidence defies everything that you've said. The eyewitnesses defy everything you said. Your own words defy everything you've said. You're saying. There's a presumption for prison in this case. Well, let me go ahead and finish my recidivism and factors. I will note under the less likely that the defendant has led a law-abiding life for a significant number of years. While there's a significant criminal history, the last thing that happened, I think there was a disorderly more recently, but aside from that, it goes back at least 20 years, and I will note that. There's a presumption for prison, it's not overcome. Prison's consistent with the purposes and principles of sentencing. You refer to this as an accident, reckless conduct. I don't see it as reckless conduct. It was intentional conduct. And it wasn't an accident, it was an assault. Prison's consistent with the purposes and principles of sentencing. You're not amenable to available community control sanctions. Therefore, it will be the sentence of this court. First off, I will make the findings that the parties agree to. Count 1 and 5 will merge with count 2. Count 3 and 6 will merge with count 4. Count 7 will merge with count 8. Those are the counts that the state elected to go forward on, counts 2, 4, and 8. On count 2, it's a sentence of this court. Defendants serve an indefinite prison term of a minimum of 4 years, maximum of 6 years. On count 4 is a sentence to the court. Defendants serve a term in prison of 4 years. On count 8 is a sentence to the court. Defendants serve a term in prison of 12 months. Counts 2 and 4 are ordered to be served consecutive to each other. Count 8 will be served concurrent to the sentences in 2 and 4 for an overall aggregate total indefinite prison term of a minimum of 8 years, maximum of 10 years. There's credit for 43 days the defendant's already served. Court further finds that the deadly weapon used in counts 2 and 4 was a motor vehicle. And accordingly, a mandatory license suspension is required to be imposed for counts 2 and 4. And order that a mandatory life suspension be imposed for counts 2 and 4, 3 years for count 8. And order restitution. Mr. Cadis, John Cadis, in the amount of $33,248.85. Those are his medical bills that he has incurred. He has no insurance. Those are all in collections. I will permit those, or order that those be offset by any insurance proceeds that the victim may receive. And Mr. Martinez, if you need to file something down the road to modify that based on information received at some point regarding any proceeds received, the court will certainly entertain that. Defendant's ordered to pay all costs incurred in this action.
Judge, what was the suspension on counts 2 and 4?
A lifetime
Thank you.
revocation. If I didn't say that, I apologize. Lifetime suspension on 2 and 4, 3 years and 8. Is there anything else for the record at this time, Ms. Tuttle?
Just the appellate rights, Your Honor.
Oh,
Thank you.
thank you. I need to advise you, Mr. Setzer, that you do have the right to appeal the conviction in this case. Specifically, if you're unable to pay for the cost of an appeal, you have the right to appeal without payment. If you're unable to obtain counsel for an appeal, the court will appoint one for you to represent you and pursue that appeal without cost to you. If you're unable to pay for the cost of documents necessary for an appeal, which includes a transcript of all the trial and all the other proceedings we've had here in court, those documents will be provided for you without cost. And you have the right to have a notice of appeal timely filed on your behalf. Ms. Martinez, do you know what the defense intention is at this time regarding, are you going to be representing him on appeal? Is he going to need someone appointed? You don't know that yet?
I don't know yet, but
All right,
I'll
well,
make sure that I either file a motion to appoint someone or file the appeal on behalf of Mr. Setzer.
Yeah, and minimum, even if you're not going to do it, if it's coming close, you can file a notice of appeal and
Correct.
get someone appointed after that if you need
Always
to
do
do
that, yes.
Lastly, the court finds in this case for counts 2 and 4 that consecutive service is necessary to protect the public from future crime, to punish the offender, that the sentences are not disproportionate to the seriousness of his conduct and to the danger he poses to the public, and that these 2 offenses were committed as a part of course of conduct, and that the harm caused by these 2 counts, these 2 offenses, is so great or unusual that no single prison term for any offenses committed as a part of the courses of conduct adequately reflects the seriousness of his conduct. There's 2 separate assaults here, 2 separate victims. Should be separate punishments that should be served for each of these acts and should be recognized for each of these acts. And that's why this consecutive service is appropriate and necessary.
Your Honor, also mandatory post-release control advisements, since it's a felony too, assault.
Thank you.
Thank you.
Lastly, I need to advise you that upon your release from prison, you will be placed on post-release control, in this case for at least 18 months. It could be up to 3 years. It's mandatory. Post-release control, if you violate any of the conditions of post-release control, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall total of 50% or half of the prison term imposed by this court. And one last thing. I also need to advise you for the record here, Mr. Setzer, that you have been sentenced to a non-life felony indefinite prison term. And in regards to that, there is a rebuttable presumption that you will be released from the service of that term after you have served the minimum sentence of 4 years. Now, that is not guaranteed. There's a presumption that you'll be released at that time, but that is not guaranteed. If at a hearing, the Department of Rehabilitation and Correction has a right to rebut that presumption at a hearing, and if they present evidence at that hearing that you have committed institutional infractions of the rules, not conducted yourself in accordance with the rules, if you misbehave, basically, if you're not sufficiently rehabilitated, if you pose a threat to the community, if any of that is established, that presumption would be rebutted, and you would not be released at the end of your minimum sentence. The department would select a new date that would represent your release date, and there would be a presumption then at that new date that you'd be released, unless again it's rebutted by evidence presented that you are still not sufficiently rehabilitated or still being a threat, or they continue to violate the institution's rules. Under no circumstances, however, can you be kept in prison beyond the maximum sentence of the 6 years that was imposed. All right, I think that covers all the things, advisements that need to be said. Is there anything else, Ms. Tuttle?
No, Your Honor. Thank you.
Mr. Martinez.
No, Your Honor. Thank you.
This morning, the State of Ohio versus Theon Rufus, case number 25 CR 896. The defendant is present, open court with his attorney, Mr. Hurley. We are here today for an in-court arraignment. This case was bound over and indicted on October 6th on a 9-count indictment. At the time that it was in the Painesville Municipal Court, bond was first set at $25,000 cash surety or 10%, and then on June 23rd, before it was bound over at the preliminary hearing, it was reset to own recognizance with a GPS monitor. The defendant has been on a GPS monitor since that time. However, Mr. DePiro filed a motion to revoke that bond on October 1st of this year for the reason that the defendant had not paid his GPS, and in his motion he states that the defendant was supposed to have come to pay at On Track on August 18th, August 25th, September 2nd, September 3rd, September 5th, September 8th, and September 11th. He stated he would come and pay on all of those dates. He did not show up, and Mr. DePiro still gave the defendant some time in order to pay for his GPS, but ultimately filed to revoke his bond on October 1st. The court granted that, and the state is recommending that bond remains revoked.
Thank you. Mr. Hurley?
Oh, yes, thank you, Your Honor. Your Honor, thank you, Your Honor, for the opportunity to speak, Your Honor. I respectfully ask that the bond be reinstated, Your Honor. This was an issue with him picking up new charges or absconding, Your Honor. It was basically a financial issue. I talked to his mom. She's able to help pay that fee. Mr. Rufus himself said he was on his way to pay that fee. We just respectfully ask that the bond be reinstated, Your Honor. These are some very serious charges, Your Honor, and it'd be easy for me and Mr. Rufus to compile a strategy with him being out, Your Honor. Thank you, Your Honor.
Well, Mr. Rufus, did you receive a copy of the indictment in this case?
Yes, Your Honor.
You had a chance to look it over?
Yes, Your Honor.
Now, you have the right to have me read this indictment to you, and I'm happy to do that if you want me to, but you can also waive the reading if you want. What would you like to do?
I would like you to read it, Your Honor.
Very well. Count one, it's alleged that Theon Rufus, on or about March 1st, 2025, in Lake County, Ohio, did knowingly, by any means, cause physical harm to the property of another person, that being a car windshield, without the consent of that other person. In committing the offense, it's alleged Theon Rufus did create a risk of physical harm to a person. That conduct constitutes the offense of criminal damaging or endangering. It's a misdemeanor of the first degree. Count two alleges that on March 31st, 2025, in Lake County, Ohio, that Theon Rufus did knowingly, by any means, cause physical harm to the property of another, being a car window, without the consent of that person, and that in committing the offense, Theon Rufus did create a risk of physical harm to a person. That's criminal damaging or endangering, a misdemeanor of the first degree. Count three is the same offense, alleged that on or about March 31st, 2025, in Lake County, Ohio, that Theon Rufus did knowingly, by any means, cause physical harm to the property of another, being car tires, without that other person's consent. That constitutes the offense of criminal damaging or endangering, a misdemeanor of the second degree. In count four, it's alleged on or about March 31st, 2025, in Lake County, Ohio, Theon Rufus did knowingly cause or attempt to cause physical harm to another person by means of a deadly weapon, that being a knife. That constitutes the offense of felonious assault, a felony of the second degree. In count five, it's alleged on or about March 31st, 2025, in Lake County, Ohio, that Theon Rufus did, with purpose to deprive the owner of property, being a prosthetic leg, knowingly obtain or exert control over that property without the consent of the owner or a person authorized to give consent. The value of the property involved was more than $1,000, which makes the offense theft, a felony of the fifth degree. Count six alleges on or about March 31st, 2025, in Lake County, Ohio, that Theon Rufus, in attempting or committing a theft offense or in fleeing immediately after the attempt or offense, did use or threatened immediate use of force against another person, which constitutes the offense of robbery, a felony of the third degree. In count seven, it's alleged on or about March 31st, 2025, in Lake County, Ohio, that Theon Rufus, in attempting or committing a theft offense or in fleeing immediately after the attempt or offense, did inflict, attempt to inflict, or threaten to inflict physical harm on another. That constitutes the offense of robbery, a felony of the second degree. In count eight, it's alleged that on or about March 31st, 2025, in Lake County, Ohio, that Theon Rufus, in attempting or committing a theft offense or fleeing immediately after the attempt or offense, did have a deadly weapon on or about his person or under his control, that being a knife, that constitutes the offense of robbery, felony of the second degree. Lastly, in count 9, it's alleged on or about March 31st, 2025, in Lake County, Ohio, Theon Rufus, in attempting or committing a theft offense or fleeing immediately after the attempt or offense, did have a deadly weapon on or about his person or under his control, that being a knife, and that he displayed the weapon, brandished the weapon, indicated he possessed the weapon, or used the weapon. That constitutes the offense of aggravated robbery, a felony of the first degree. Do you understand what you're charged with in these counts?
Yes,
Any
Your Honor.
questions for me about the charges themselves?
No,
Then as to each of these 9 charges, what is your plea at this time?
not guilty, Your Honor.
The court will enter a plea of not guilty. As to the matter of bond, obviously these are very serious charges, and bond was initially set in the municipal court at a high amount. The municipal court was willing to modify that on the condition that the defendant would be on GPS monitoring, and he has not complied with that condition that was necessary for that. Your response indicates that he's indigent and homeless, yet he was arrested at his house. So I'm not sure how he was homeless, but he was given an opportunity to be on the bond, a reduced bond, with specific conditions, and he hasn't complied with them. So bond is going to remain revoked at this time. Is there anything else for the record, Ms. Contour?
Nothing further, Your Honor.
Mr. Hurley?